Okay, Assalamualaikum warahmatullahi wabarakatuh. This is the second part of our topic for the lecture on undue influence. Okay, I'm clicking the button, admitting all. Okay, and in the last lecture, we have covered the first type of undue influence, which is actual undue influence. Okay, and usually it needs certain evidence in order to prove there was actual exertion of undue influence on the part of the complainant. And then most of the time it's very hard to prove. Okay, and then we don't have many cases to be discussed, so we only focus our discussion on the landmark case of, what's the case, class? Morley. Okay, if you remember, okay, this is the case. All right, Morley and Lonan. And this case, one of the not so many cases in which complainant or plaintiff, the executor, okay, of the deceased was successful, okay, in their claim to get back the property. So for today, we are going to focus on presumed undue influence, which is the most common one, okay, and this is the second category. So in order for the complainant to be successful in proving the case under presumed undue influence, so the complainant or the plaintiff must show or must prove two things, two requirements or two ingredients or elements here. The first one, which is very obvious, wrongdoer, the one who exerted undue influence, was in a dominant position. Here they don't stand on equal footing. I mean, one of them is in a much more superior or much more dominant. Okay, that's why we call it as a wrongdoer was in a dominant position in his relationship of trust and confidence. So most of the time it involves trust and confidence, okay, with the complainant. So they are not totally stranger to each other. Okay, that's why they have this trust and confidence. And then another things to be proved, okay, another requirement, right, for the complainant to be proved is that the impugned or the disputed, okay, the transaction which is being challenged was so unfair. So the keyword here is unfair, unfairness, okay, to the complainant. So if the complainant can prove these two elements, then yes, the case will fall under presumed undue influence. Okay, now before we go further, okay, in discussing presumed undue influence, we want to know, okay, now we can make comparison, okay, what's the difference, okay, between actual and presumed, because both are under the same topic of undue influence. So, right. So basically for presume, okay, there's no need to produce evidence, even the word itself, okay, presume in the here, the court will presume, okay, meaning that here it is in favor of the complainant. There will be presumption for him, okay, because it's very hard to provide or to produce evidence, okay, to show undue influence took place. So for presume undue influence, okay, there is no need to produce evidence, okay, that the wrongdoer actually used or actually exerted undue influence in order to secure the transaction, in order to obtain the impugned transaction. But of course, because we have two elements, the complainant must prove unfair advantage. So in comparison, comparing with actual, there's no need to prove unfair advantage. Just prove actual assertion that it really took place. So we don't care whether transaction was in effect, was it fair or unfair to the complainant. But for presume, because we just presume it happened, we presume undue influence took place. So there must be, there must be a requirement and there must be evidence of unfair advantage. Whether is it fair or is it unfair to the complainant. So now this is the landmark case, leading case for presumed undue influence. The case name is Alcott and Skinner, 1887, very old case, 19th century case. Who were the parties here? So plaintiff, she was a member of a sisterhood, Alcott here, and who was a defendant? Okay, defendant belonged to the same sisterhood, but slightly higher in rank. Okay, defendant served as spiritual advisor, okay, of the sisterhood, whereas plaintiff is just a normal member, okay, of a sisterhood. And then when it happened, plaintiff was 27 years old and she was unmarried woman, okay. And when she joined the sisterhood, okay, she was bound to observe the rule. So there are two important rules here. The first one, rules of poverty, which is, what does it mean here? To relinquish, to let go all earthly possession. all dunyawi possession, whatever related, for example, your money, your car, your house. Okay, so you have to let go, relinquish, okay, everything. Another rules is that rule of obedience. Okay, you really have to obey. Meaning that here you cannot seek advice of anyone outside the community of sisterhood, okay, without permission of the advisor. So because of that, after Olcott here, after she joined the sisterhood, so she transferred her stocks. Okay, stock here meaning that is shares. Okay, and he made two things here, two transactions. First, she transferred her stocks, and then she made a will. Okay, remember the word will here. Will take place after the death. Okay, so she made a will. For whom? In defendant's favor. Meaning that okay, after, if I die or after I die, I will leave my property, okay, to the advisor, spiritual advisor of the sisterhood. And later, she decided to leave the sisterhood. So she didn't want to proceed, okay, with the sisterhood. So she left the sisterhood, and then she quickly, okay, immediately she revoked the will. Meaning here the will is no longer enforceable. So she revoked the will made in favor of the religious group. Okay, but remember she made two contract or two transactions. But in terms of stock, which she has, which she had transferred to the defendant or to the religious group, she delayed. She delayed in claiming back, okay, the stock here. So as far as the will was concerned, okay, yes, the court agreed that the will was voidable by reason of undue influence. So she was under religious influence, okay, of the spiritual advisor. So if you refresh, if you compare with Molly and Lorna, it's about brotherhood, kan? But then Molly Lorna, there was evidence, okay, and Molly actually realized, okay, when he gave away the money, okay, he was under influence. He realized it. He noticed about it. But Olcott and Skinner here, she didn't realize it. Okay, only later after leaving the sisterhood, then only she actually was under undue influence when she made the transaction. So that's the difference. And maybe in Olcott Skinner, it's very hard to prove. There's no direct evidence, okay, to prove that was she aware that she was under influence when she made the transaction? Maybe there's no evidence to prove that. That's why the case was brought under presumed undue influence, and she managed to prove it. Even though she won the case of to set aside, okay, the will here. All right, now we are talking about trust and confidence. Still the first element, okay, the first requirement of undue influence. So usually it requires fiduciary relationship, or in other words, it requires relationship of trust and confidence. So it cannot be any person here, any individual. There must be trust and confidence between them, okay, between these two contracting parties. And from the judgment or quotation by Lord Brown Wilkinson, okay, in the case of Barclays Bank PLC Private Limited Company and O'Brien in 1993, there were two further categories, okay, as far as trust and confidence is concerned. To make it easier, okay, for the complainant to prove the case. So here, Lord Brown Wilkinson, the Lordship, he said that there were two ways in which a confidential relationship may be established, may be proved, is either under class 2A or class 2B. So what is all the classes here? So for class 2A, it will be very simple, automatic. Okay? The law will have, okay, the court will have the complainant. In the eyes of law, okay, under class 2A, persons in certain fixed relationship, okay, the court will deem straight away that they are in a dominant position. For example, solicitor and client. So solicitor would be in the dominant position as compared to client, and both of them has trust and confidence. Okay, and then medical advisor and the patient. So most of the time, medical advisor will be the one who is in the dominant position. So and there is trust and confidence between. The simpler term is doctor lah. All right, doctor and patient. All right. But class 2A, there are only certain relationship. Okay, what if it doesn't fall under class 2A? It will go under class 2B. Okay, so if there is no relationship falling within class 2A, which is there is a fixed list actually. So now the complainant must prove the actual existence of relationship of trust and confidence. For example, relationship of husband and wife. Meaning that here sometimes husband dominate the wife, or sometimes wife in the dominant position compared to husband. So must prove to the court. So the court won't simply assume or presume straight away. And also siblings, okay? Elder sibling, younger brother, younger sister, elder sister. So that one, yeah, generally, okay, on the face of it, there is trust and confidence between siblings, okay? But then it must be proved to the court because we don't know who is dominating whom actually, okay? And maybe other categories of relationship, but it's just a common example. Okay, now we are going to discuss case law to show the application. Okay, remember we are still discussing is about dominant position by proving trust and confidence between the parties, okay, between complainant and defendant. So for class 2A cases, okay, we have at least 1, 2, 3, 4. Okay, all Skinner we discussed already. It's about sisterhood. So we have Public Finance Berhad and Lee B. Rubber Factory Sunan Berhad. We are going to discuss after this. We also have Rosli Daros and Mansur Haji Saad. We are going to discuss as well Ong Bancai and Siang Mong. So these are all cases which fall under class 2A. Okay, and for class 2B, we have at least 3 cases. You have more. Okay, you have more in your textbook, but this is some of the cases that you are going to discuss together. So class 2B cases, we have Southern Bank Berhad and Abdul Rauf bin Rakinan. We have Tate and Williamson, that one is common law. We also have Polygram Records, Sunan Berhad, and the search. Okay, let's have a look at all the cases. But then this is the latest development, okay, with regards to classification. Okay, remember, you cannot find this classification under section 16. Okay, these are all a common law approach, and generally we do follow. So in year 2001, okay, House of Lords, in the case of Royal Bank of Scotland and Actress number 2, gives some indication that, the Lordship said, well, we don't care actually. It's not really significant to prove the case under 2A or 2B, so long there is elements of undue influence. Okay, so meaning that it's not really important. It's not really significant. All right. So dicta lah. Dicta is the remarks, okay, by the Lordship here. So it casts doubt whether there is a need, okay, to prove class 2A or class 2B. But then even among the Lordship here, some do not favor, okay, but some said, okay, we just maintain, okay. So Lord Nichols seems to recognize. So, and then as far as Royal Bank of Scotland case is concerned, it's about class 2B. Okay, that's why if class 2B, we have to look further, deeper. Okay, what's the evidence? Improving relationship of trust and confidence between the parties. If class 2A, it is simple. It is automatically presumed. Okay, now we go to the cases under class 2A. But for public finance, we are not concerned with the facts, but we are concerned with the ratio, okay, with the rule which was established by highest court. Last time we have Supreme Court, okay, before we have Federal Court, right? This is the court which sits at the apex, okay, of the hierarchy of courts in Malaysia. So the case is Public Finance and Lee B. Rubber Factory, 1994. So in this case, Supreme Court, okay, expressly, mean that here, this is to supplement section 16. Okay, section 16 it doesn't say anything about this. So Supreme Court in this case give example of certain classes of relationship which puts the person in a position to dominate the other. This is some of the fixed list. Okay, the list meaning that here, if your case fall under any of this list, then your case is easy. The first requirement is considered fulfilled already. Parent and child, person in loco parentis, in the position of parent, okay, and his charge. And then guardian and ward. Okay, here ward here it doesn't refer to ward in the hospital. Ward here it means a person, okay, especially a child who is legally put under protection of law of court or a guardian. Okay, I think in Malaysia we have like JKM kan, okay, Jabatan Kebajikan Masyarakat, all right. And then doctor and patient, okay, like the case, the one which was being pronounced by the court just now. Solicitor and client, okay, lawyer and client, spiritual advisor, okay, and member of his congregation. So it's like the case of Olcott Skinner and Molly Lonan, okay, and also trustee and beneficiary. Meaning that for this particular relationship, one person is in a dominant position over the other. Okay. Oh, we have. All right, we have the facts. Okay, I apologize. So we have the facts as well. I thought we are just focusing on the ratio. So we focus on both. Okay, this is judgment by Supreme Court. Okay, public finance and Lee B. Rubber Factory. So the word public finance, you can see, oh, this is finance company, obviously. So plaintiff is a finance company, and who was the borrower? I mean, who was the defendant here? We have three defendants altogether. So the first defendant is the company, okay, the borrower company. Second defendant was the guarantor. Okay, third defendant was also the guarantor. But in terms of these two defendants, okay, the first guarantor is the husband. The guarantor, both guarantor. Okay, the second defendant is the husband. Third defendant is the wife, and both stood as the guarantors, okay, for the loan that the company took. And then there was default in payment. All right. So now the bank, okay, public finance, is asking back the money. So now plaintiff obtained judgment against the defendant. But somehow later, not only 2-3 months, okay, 2.5 years later, okay, second and third defendants, they wanted to challenge and set aside the judgment on the ground that, okay, what's the reason? What's the basis here? The third defendant, okay, the wife, had signed the guarantee under influence from the second defendant. So this is their reason. They say, oh, actually, one guarantee agreement was tainted by undue influence. Okay, but the court dismissed the application. I mean, the court, did not decide in their favor. Okay, what's the reason? Why is that so? Okay, so the reason is that the defendant, remember the time factor here, 2.5 years. Okay. So the defendant, okay, both of them, husband, wife, or even the company here, they delayed in applying to set aside the default judgment. And because of that, they are guilty of laches. So they cannot win the case. Because why? They delay. Okay, there was a delay, considerable delay here. And then the finding by the court here, okay, after all, okay, having considered all the evidence, okay, all the facts, the court said that at all material times, okay, the second and third defendants, husband and wife here, the guarantor, they knew, okay, and they approved, okay, of the contents of the guarantee agreement when they sign it, okay. And then that's why the court said, well, the plea of undue influence was not available to the third defendant because you know about it, okay, you were aware of the content when you signed, okay, you cannot really plea, okay, you cannot claim that you were under undue influence. And then in terms of relationship between husband and wife here, the court said that affection and confidence, okay, trust inherent in the marital status did not, okay, ipso facto, as a matter of fact, amount to undue influence in the eyes of law. So it doesn't, it doesn't fall straight away under class 2A, right? So this case actually can be discussed under class 2B, but we focus more on the remarks or quotation, okay, ratio by Supreme Court, in which Supreme Court listed out a list of relationship, okay, which is recognized, okay, under class 2A. But as far as the facts were concerned, okay, it is a case under class 2B because it involves husband and wife. Okay, we go to the next case, still discussing class 2A under trust and confidence, which is under first element of presumed undue influence. Okay, don't be confused. So the case is Rosli Darus and Mansur Haji Saad, okay, reported in year 2001 in CLJ, Current Law Journal. So who was the plaintiff here? Who was Rosli Darus? He was an adopted child, okay, not biological child, adopted child. So who was Mansur Haji Saad here? He was the guardian, okay, and actually he was in loco parentis. So he served, he acted as the guardian. So now we go to the facts, okay, all the unique features of the facts here. So Rosli Darus, the plaintiff, he lost his adoptive father, here he was being adopted, but at the age of 11, he lost his adoptive father. And then since then, okay, from the age of 11 years old, very, very young, okay, the defendant, so who took care of him? So defendant, that is the brother of his adoptive mother, not adoptive father, brother of adoptive mother. It's like adoptive uncle, more or less, okay? So they live together in the same house, and this Mansur Haji Saad, okay, the uncle, he provided food, okay, after all, he was just 11, okay, he provided food, clothing, okay, money, expenses, but the mother was still alive, okay, during that period of time. And 11 years later, okay, plaintiff's adoptive mother, okay, now the mother died, and now he was already 22, but he was being dependent, okay, on the defendant. So defendant continued his role as guardian to the plaintiff. That's why we are using the word in loco parentage, the defendant was not really the adopted parent. Okay. Okay, and then when this plaintiff, he transferred his property lah, all right, to the defendant, and then later the transaction was being challenged for being affected with undue influence. And when the case was brought to the court, okay, defendant testified. Okay, when the counsel asked the defendant agreed. Defendant testified that yes, plaintiff always listened to his advice and instruction. I mean, this is something which is common or logical. And then, yes, this is about transfer. Okay, plaintiff transfer his land to the defendant. So that's why, on the face of it, we can see, oh, there could be undue influence between these two people here. All right, they are not stranger to each other. Okay, when the plaintiff transferred his land to the defendant. Okay, and this is the finding by the court. All right. Defendant, okay, as far as the relationship was concerned, defendant was in loco parentis, okay, in the position of parent. And as far as plaintiff was concerned, despite the fact that he was 22 years old, but he was staying from 11 years old, okay, until 22 years old. So plaintiff, he was unemployed. And then he was without parents, okay, not orphan already. And then in terms of dependency, he was totally dependent, okay, on the defendant for his daily subsistence, because not working, okay, everything must be asked from the defendant. So the finding by the court is that the defendant could dominate the will of the plaintiff if he wanted to. It will be different if the plaintiff got his own job, okay? But then the fact stays as it is, like he was unemployed, okay? And then for all intents and purposes, this is also another observation by the court. For all intents and purposes, okay, I mean a very strong wording here. The first defendant had failed, okay, miserably. Okay, another word, fail. Okay, not only fail miserably. Okay, very failure, total failure. To elude, okay, to elude means refer indirectly or by, that's the meaning, okay, by suggestion or to elude to cheating. So here, to elude evidence, okay, tending towards bona fide. Meaning here, whatever transaction transfer here, it wasn't done bona fide. And then it's on the part of the defendant to rebut the presumption. We haven't come to the stage of rebutting yet. But as far as liability is concerned, okay, defendant must rebut the presumption. But he could not rebut. Okay, after all, he testified in the court. He said, yes, he always listened to me. So how do you rebut the presumption? So the court will presume that it was being tainted with undue influence when the transfer was made. All right. So that's the case of Rosli Darus and Mansoor Haji Saad. Okay, we still have time because I haven't received any reminder yet from Zoom. Okay, another case. Okay, just now, loco parentis. Now is between solicitor and client. Okay, another example under class 2A. Okay, we are talking about trust and confidence. Ong Ban Chai and Siang Mong. Okay, the case was reported in year 1998 in MLJ. Okay, this is appeal case. So who was the appellant? The appellant was the purchaser, and actually the appellant was advocate and solicitor. Okay, and then later he purchased the property. And who was the respondent here? Respondent was the client, and he, at the same time he was the vendor, the one who sold the property to the solicitor, and he owned the land. Okay, he was the landowner. So they entered into sale and purchase agreement. To purchase what? To purchase respondent's land, okay? The client's land, basically. And then in the agreement, okay, appellant, the lawyer, he was to complete the payment of the property within a year. So he has 12 years to complete the installment, okay? And then until the property is registered in his name, okay, meaning there's no transfer of the name of property yet, okay, until you finish your final installment. So respondent, the client, because he trusted his lawyer, okay, respondent appoints appellant as his lawful attorney. Okay, you become my lawyer and I'm selling the property to you. So it's clash of interest here, okay, to deal with the property as if the appellant were the owners there. I mean, okay, I trust you, so you can deal with my property, okay, as if you are the owner, whereas he's not the owner yet. Okay, there's pending payment here. And then after whatever arrangement here, okay, sale and purchase here, appellant, the lawyer, okay, haven't completed the payment. Now the lawyer give respondent a loan, okay, quite big amount, 682,000. Okay, this is friendly loans. Okay, and then because respondent haven't received the payment, okay, of the money, payment of the land that he sold to the appellant, to the lawyer. Okay, respondent now cannot pay the loan, unable to pay the loan. Remember, there were two transactions here. Okay, first sale and purchase and later loan. And And then lawyer said, okay, never mind. Okay, we just treat the loan that I give it to you. Okay, we set off, okay, against the selling price. So as if when I give you the loan, actually, it is the selling price lah. Okay, as if I'm making the payment. All right. And then at the same time, okay, he made use the power of attorney. Power of attorney mean that here, okay, I give you everything, all the legal power to deal with the property. So because he has the power to deal with the property, so he transferred the share, okay, of the property to himself. Okay, remember he hasn't paid completely, okay, the payment, but he just said, okay, set off, and then I'll do whatever necessary. So he abused actually, okay, his power as the lawyer. So now the property is registered in his name. So appellant, the lawyer, okay, we have 10 minutes left. Okay, the appellant sold the property to second and third appellant. So we have 3 appellants here. Okay, the purchaser, subsequent purchaser, and the price was 1.6 million. So he made profit here. Okay, that's why he abused his power to make this profit. Now the landowner, okay, of course, was not agreeable. Okay, you haven't completed the payment and you actually use the power of attorney I have given you, I mean, not in the way that I want it to be. Okay, the respondent successfully sued first appellant. Okay, and now the client, okay, he obtained court order for the registration of the property in his name. I mean, transferred back the property to his name. Okay, and this is a judgment by the court. Okay, this is observation. The court said, well, you are the lawyer, okay, you acted for your client. So the first appellant, okay, the solicitor, the lawyer here, cannot use the power of attorney to transfer the said property into his own name. Okay, you had abused your trust and confidence, okay, as lawyer, advocate, and solicitor reposed in him by the client, by respondent. And then as far as the client was concerned, okay, there was clash of interest. You are supposed to appoint your own independent lawyer, okay, to advise and to act for you in the very huge amount of transaction, more than 1 million here. So now the court found in favor of the respondent. Okay, so the court held that findings of undue influence and breach of trust, okay, committed by first appellants against the respondent. So now, as far as relationship was concerned, is between lawyer, I mean client and solicitor. And solicitor actually abused his dominant position. Okay, it's about trust and confidence between them. Client trusted the lawyer, but the lawyer abused the trust and confidence. And there was finding of undue influence. Okay, right, that's on Bancai. Okay, Olcott Skinner, we have discussed. So plaintiff was a professed sister. Okay, and then of course she was bound to make absolute submission to the defendant because defendant was the advisor, superior, okay, of the sisterhood. And then how about the independent advice? Could she get the advice from outside the community of sisterhood? Cannot. That's why when she gave away the property, okay, sorry, the stock, okay, the stock and shares. I mean, it was lack of free consent, free will, okay, not really, it's not the things that she wanted to do. She was under undue influence. Hopefully we have time to discuss this case. This is under, still, is it, can we go back to the, here. All right, so we are done with class 2A. Okay, class 2A, we discuss public finance. We discuss Rosli Daros, okay, loco parentis. We discuss on Bancai just now. I mean, it's between solicitor and client. And we discuss Olcott and Skinner. So now we are going to discuss class 2B, still under a relationship of trust and confidence. Meaning that here the court won't simply presume straight away. It's not automatic presumption. No? Okay, we have the case of Southern Bank, Tate and Williamson, and Polygram Records and the search. But it's quite a lengthy discussion. Okay, even the case is quite long. Yeah. Okay, Southern Bank. I think we have to stop now. Okay, we have few slides. Okay, for Southern Bank, and we have Tate and Williamson. Okay, and we have Polygram Records. So we cannot finish it today. Okay. All right, so we stop here. I stop share and stop record.